Great to see that. And I would say we go into the session, and I would again like to welcome Kathleen Tobak and Jasper. Thank you for joining us this morning. It's a topic that you are quite that you're familiar with, because you are working with associations on some of those cases, and we look forward to listening and hearing about that. So I would like to give the floor then to the two of you, and thank you for being with us this morning.
Thank you, Kai. So also from my side, welcome everybody, and thank you for joining our workshop on COVID contracts and event cancellations. My presentation will be divided in two sections. First, I will shortly discuss the general legal principles that apply to the cancellation of events due to COVID. Please note, however, that our time to discuss this topic is rather short, so the discussion of these legal principles will be limited to a very general and broad sketch of the basic concepts. But of course, should you have a question, don't hesitate to contact me or my colleague after the session. We will be happy to help you further. Then secondly, I will apply these basic concepts more in depth on a case study of a case that we have handled in our day-to-day practice. And here I will already try to give you an answer to some of the most common issues. I scheduled this presentation for about 20 minutes, and thereafter you will be asked to split up in the so-called breakout sessions, where you will be able to share your findings, your insights and experience with other attendees in this seminar. And finally, we gather together again and we end the session with a Q&A round, during which we, myself and my colleague Jasper, who is here, and we will try to answer to certain of your questions. So I go through some legal concepts with you in a nutshell. It is a basic rule common to all legal systems that contractual obligations between contract parties are binding. This is the so-called principle of pacta sunt servanda, a Latin expression. Whenever a party fails to fulfill its contractual obligations, that party can be held liable. This will generally mean that this party can be forced either to comply his contractual obligations, either if it is not possible anymore, he will be forced to pay compensation. Most legal systems also have one or even two very important exceptions to this principle of pacta sunt servanda. This is the principle of force majeure at one hand and the principle of hardship on the other hand. Very shortly said, based on these principles, if a party is unable to perform its contractual obligations due to force majeure or unforeseen circumstances, that party shall not be held liable. Now, the exact conditions that determine when a situation of force majeure occurs and also the consequences thereof can differ from country to country. Therefore, in an international context, it is always essential to determine which law applies to the contract. And often, contract parties determine the applicable law in the contract itself. This is generally allowed, although there are some exceptions, for instance, for consumer contracts, but those exceptions are not relevant most of the time on the contracts that we discuss today. And then, In the case the parties have not determined the law applicable in their contract, the applicable law will have to be determined based on the rules of international private law. This is a set of rules in every country to determine which law applies to international situations, and an international situation may be the case where a contract is entered into between a party based in one country, a party based in another country, and to make it more complicated, for instance, for services that have to be rendered in a third country. So the rules of international private law for countries within the European Union, these rules have been harmonized in the Rome I regulation. And according to that Rome I regulation, in the absence of a choice of law made in the contract, a contract for the organization of an event will typically be subject to the law of the country where the event organizer has his habitual residence. You can read this in Article 4 of the Rome Regulation. So that article sounds as follows: a contract for the provision of services shall be governed by the law of the country where the service provider has his habitual residence. And this may be annoying when you have not provided for a contractual law choice in your contract. Then it is possible that your contract that you have entered into with a service provider in a foreign country may be governed by the law of that foreign country. And this can be very annoying, especially in case you have a dispute. Then you cannot just go to your legal advisor or your lawyer and ask what is your position in that conflict with your service provider, because your lawyer, who is based in your own country, he does not know the law of the foreign country that is applicable to your contract. So this complicates determining your legal position in the case of a dispute. So the first thing we advise to you while entering into a new contract is to have a look at the law choice and try to have your contract governed by your own law or the law that you are familiar with. So a very important thing to be aware of while entering into contracts, the law applicable to the contract. And then, in addition to determining the applicable law, the parties can also derogate from the legal principles governing force majeure in their contracts. And in most countries that we are aware of, the rules governing force majeure are indeed not binding. For example, the parties can then define the circumstances that qualify or do not qualify as force majeure. Or the parties can also determine what the consequences of a situation of force majeure would be between the parties. Now, when does a situation of force majeure occur? As the specific conditions that determine whether a situation is to be qualified as force majeure differ from country to country, I will not discuss in detail the exact conditions. But in general, and this seems to be most common to a number of countries that we are aware of, you can distinguish two basic criteria to determine a situation as force majeure. First criterion: the change in circumstances is not attributable to the contract party that has to perform. This means that the circumstance should not be caused or could not be prevented by the party who has to perform. And in Belgium, this traditionally requires that the circumstances should be unforeseeable or inevitable. This criterion requires a very factual application, which often makes it quite difficult to apply. And then the second criterion to determine a situation as force majeure is that the change in circumstances makes it impossible for a contract party to fulfill his contractual obligation. Now, when exactly it has become impossible for a contract party to fulfill his obligations also depends very largely on the specific facts and circumstances, and this will require an in-depth examination of the facts of the case. And in Belgium, this criterion is traditionally applied very strictly. It has to be really impossible to perform the contractual obligation. The mere fact that the original obligation has become more difficult or more burdensome to execute is not enough to determine a situation of force majeure. Recent doctrine and case law, however, suggest to apply this condition in a more reasonable way, and as soon as it becomes reasonably impossible to perform the obligation, recent case law accepts that there is a situation of force majeure. Now we have qualified a situation as force majeure. The question is, of course, what are the consequences of such a situation? And also here, the precise consequences of a situation of force majeure can vary depending on the applicable law. And again, the basic rule is also similar in most countries. Once a situation is qualified as force majeure, the performing party shall not be liable for not being able to perform its contractual obligations. This means that this party cannot be forced to perform, nor can he held liable for not performing, so he cannot be forced to pay compensation or damages. Often, the obligations will only be suspended temporarily, and as soon as it becomes possible again to perform the obligations, the party is liable again to perform his contractual obligations. However, if it has become definitively impossible to perform the contract, for instance, an event had to be organized on a certain date or within a certain year of celebration, or the further performance becomes completely useless for the other party, then the party will be released from its contractual obligation. So two situations may be envisaged here: the situation of a temporary suspension of the execution of the obligation, and the situation of a definitive suspension and release from the execution of the obligation. Now, when a contract party is definitively released from his obligation due to force majeure, this also means, and this is also important, that the other contract party shall be released from his obligation in return. For example, if a congress organizer or an event organizer does no longer have to organize an event, the customer also will no longer have to pay for the event. And this can lead to very complex discussions. For instance, what if the organizer has already performed part of its contractual obligations? What if an advance payment has been made? If the performance of the contract has become definitively impossible, it is often a basic premise that everything that has been received for the future performance of an obligation should be returned. This can, for example, mean that part of an advance payment or the whole advance payment should be returned, however, often after deduction of the costs already incurred. So these are the consequences of a situation that is qualified as force majeure. I explained to you that there exists another concept, and that is the concept of hardship and the renegotiation of contracts. Many countries also know this doctrine of hardship. For instance, the Netherlands, Germany, France. This theory or this doctrine of hardship is not yet applied officially in Belgium, but we have a new project of the Belgian Civil Code, and the hardship theory is worked out in the new project of the Belgian Civil Code, which is not yet applicable today. So what does hardship mean? Hardship means that if the performance of a contractual obligation has become substantially more difficult due to unforeseen circumstances, then the parties are required to renegotiate their contract. You see here there are two main differences with the principle of force majeure. Firstly, the doctrine of hardship means that the obligation has become substantially more difficult, while force majeure requires that the obligation is impossible to execute. And then secondly, the doctrine of hardship requires that parties will renegotiate the contract, while force majeure suspends the performance of the contract during the period of force majeure when it is temporary, or force majeure releases a contract party from his obligations when the force majeure is definite. And then the renegotiation of a contract for the organization of an event can take multiple forms. For instance, the parties may agree to postpone the event, or they may agree on extra compensation, or they can adapt the format of the event of the Congress, and they can agree on a payment of the costs already made for a physical event that cannot be used for the organization of an online event. Many possibilities can be envisaged while renegotiating the contract in the framework of hardship. So these were a few words on the legal principles of force majeure and hardship, and the question which criteria should be examined to determine whether there is a situation of force majeure or hardship. And now, as Kai taught already in the beginning of this session, we have handled already a few cases where clients came to seek our advice on difficult situation where they entered into contracts with event organizers and where it was clear that the event could not be held. And I go through one concrete case study that we have handled and that we are still handling in our day-to-day practice. So the facts of the case are the following. In May 2020, an organization concludes a contract with a professional event organizer for the celebration of its 50th anniversary. The contract provides that the event organizer shall organize the event, book all the venues, the catering, the musician, the stage builders, and so on. The agreed concept was to hold two different events, one in spring 2021 and the second event in fall 2021. Both events would host around 500 people, and the total price agreed upon for both events is 200,000 euros, 100,000 euro for each event. Our client, the organization, had to pay an advance payment of 100,000 euro. So bear in mind, the contract was concluded in May 2020. Now, in October 2020, the organization came to us and asked for advice. There were serious doubts that the events could not be organized as foreseen in the contract, and the organization asked us whether it could end its agreement with the event organizer and whether it could claim the reimbursement of the advance payment. And then we have to ask the two questions. First of all, is this a situation of force majeure? We analyzed together the criteria to determine a situation as force majeure. And the first condition is it impossible to execute the contract and to organize the event? Well, the government measures combating the coronavirus do indeed make it impossible to organize an event of over 500 persons. However, it is uncertain how long these measures will be in place. In October, when the client contacted us, based on the situation of October, we considered it safe to assume that the event in spring 2021 would be impossible to organize. For the event in fall 2021, it was too uncertain to say. At that time, we considered that it was partially impossible to perform the contract for the event organizer. And then the second question, to determine whether we had a situation of force majeure. The condition was, are these circumstances attributable to the event organizer? And then we can say, in principle, the corona measures are not attributable to the event organizer as they were unforeseeable and inevitable. This is in principle. However, an important element in this specific case is that the parties signed their agreement in May 2020, so this was after the first wave for most countries. And in the contract, the parties did not mention any word on corona whatsoever. Given that the parties signed their contract in May 2020, the coronavirus and the different measures taken by the government do not longer constitute a situation of force majeure, because at that time it was foreseeable for the parties that it might not be possible to organize large events in spring 2021. It was largely commented indeed in the press, and the experts agreed that the pandemic would still last for a significant time, with multiple waves to be expected. The parties, therefore, should have foreseen in their contract that an event, as agreed upon, would not be possible, at least for spring 2021. So then the question is, what are the consequences of this analysis that the corona pandemic is not to be considered as an event of force majeure, given that at the time of entering into the contract in May 2020, it was foreseeable and the parties could avoid a difficult situation by taking some measures in their contract. So, what are the consequences? As we consider the corona measures do not qualify as force majeure in this case, this means that the event organizer is principally required to perform the contract as agreed. And if he can't, the event organizer is contractually liable. In that case, our client would be allowed to terminate the contract and ask full reimbursement of the advance payment and even ask compensation for damages, if any. In addition, even if the measures would qualify as force majeure, should a judge decide that it is still force majeure, then the professional organizer who is unable to organize the event will be released from his obligation to do so, and our client also then is entitled to ask reimbursement of the advance payment, as this was the payment for future services that will no longer be performed by the event organizer. The difficulty here was that in October 2020, we only assumed that the event of spring 2021 could not take place. So the question remained uncertain. So taking action to terminate the contract for contractual breach of the event organizer at that moment implied a risk that the event organizer would be able afterwards to establish that the termination of the contract was premature. We therefore advised our client to negotiate with the event organizer and find an agreement to terminate the contract by mutual consent. Now, what happened afterwards? Instead of terminating the contract by mutual consent, my client and the event organizer had agreed to postpone the spring event to fall 2021. So this can be considered as a renegotiation of the contract. But today, our client is in the same situation now and wants to deal with the uncertainty. Her intention was indeed to celebrate her 50th anniversary in this celebration year. And she concluded a contract with a concept of 2 impressive events gathering more than 500 people. But given the rising contamination figures nowadays, it's again very uncertain whether the event can be organized in fall 2021. And now the event organizer wants to change the concept and organize, instead of 2 big events, she wants to organize 10 small events. The question is whether the event organizer has the right to impose such changed concept to our client, and the answer is clearly no. As we have seen, the event organizer is obliged to organize the events following the concept that was agreed in the contract, and in the absence, he is in breach. The following question is then, is it an option that the event organizer starts to organize the agreed events already now and starts to spend the money for the organization of those events? The answer is also no. because he cannot use the money he received and take the risk with that money, knowing that there is a big chance that the event cannot take place. So the only thing the parties can do is to renegotiate the contract, to agree on a concept that is convenient for the client, and to agree on adapted budgets. And when this is not possible, to amicably terminate the contract by mutual consent and to find an arrangement on the costs already made and the reimbursement of the advance payments already received. If all this is not possible, parties will end up in court proceedings whereby the event organizer will probably be held liable for not complying with the initial agreement and will have to reimburse everything he received. This is, of course, a very sad situation that the parties could have avoided by working out in their contract a clause covering the situation where they agreed on a concept for a physical event, but where they also agreed in advance on an alternative concept should the physical event not be allowed. This is the so-called hybrid contract. Of course, the parties will have to agree on additional budget whereby both the costs of the physical event and the costs of the alternative event should be covered. But it is my experience that organizations are really willing to pay a certain price for certainty and that they want to pay additional costs of switching the format of the planned event. So they are paying an additional price for the certainty of having their event or their congress instead of the uncertainty of contracting for one specific event of which they remain uncertain if it will ever take place. So this is our recommendation for both sides, for organizations that want to organize an event and for event organizers to work together and to work out a concept whereby you can switch from one concept to another concept and to be reasonable instead of taking strong legal positions for contracts that have already been concluded, like the example I discussed with you. Please try to work out a formula that works for both parties. Renegotiate the contract, agree on another concept. Don't impose to your client when you are an event organizer. Don't impose to your client the concept that you think that should work, but listen to what he thinks that works for him and adapt the contract to that concept. That is my recommendation for existing and new contracts to be entered into. Voila, I think I can
yes, thank you, Kathleen. And I think that is actually the moment and the situation many organizations are in at the moment. It's exactly, I think, many changed, cancelled events from last year to this year. And this year we are not too much in a different situation. So we moved contracts to this year. Then now we are not sure what's happening with the contracts that we have made, that we have already moved. How do we handle this? And of course here, and this is one learning, I guess it always is important when a contract is made already, or whether it's done. And I think this is the difficulty at the moment, where we don't really understand what is the best case scenario for us to move forward when we actually come now to the next stage and want to organize a hybrid event. And how do we handle this? And we go into the breakout sessions now, just simply also understanding what are your concerns in terms of moving forward is one question. The other question is, how do you, what is currently your experience in actually negotiating with venues, with partners, with convention bureaus, whatever, to understand what that experience is and what your feedbacks are? Are people flexible? Are they not too flexible? And also, have you maybe found some solutions that, based on Kathleen's case study, maybe some other solutions, or how do you deal with this at the moment? So you'll be assigned in the breakouts now. Kathleen, thank you so much for sharing this so far. I know now why I didn't become a lawyer. So I leave that up to people like you and Sarah and Jasper, that's for sure. So let's see how many people come back.
That was too short, Kai.
Huh?
It was too short, too short.
As always, yes. We were saying that it might have been good to actually start this with the breakouts and then get that reflection about the breakouts. So I think there is more to come on this end, but it's great to see you all back. Yeah, most of you. And so the question where I hope you discuss those questions and not any others. What concerns do you have now moving forward? What experiences do you have with negotiation process at the moment? And what solutions have you maybe found to some of those issues that come up in this whole process? So I would then hand that over to MPI Belgium chapter.
I think I can start. We were the first group. So from our side, I can summarize, but Zana, if you want, feel free to jump in. So basically, the some of the, let's say, the biggest solution how we deal with this situation is came back several times is transparency, flexibility, and empathy. So we have to work, let's say, on a good relation with our clients, and but that's not enough. So we should not only rely on that, but also take it one step further and already agree and add in the contract at the beginning everything that we should agree on. Just checking my notes. I think a big concern from Zana, maybe you can explain a little bit about contracts that you have to sign today for an event for next year.
Well, I think our situation is very common to many of you. So we had in the past a physical meeting which we had to postpone twice and then finally turn into a virtual event, and that broke our cycle of events. Nevertheless, our next meeting is in 2022. So my question was what sort of legal form your contract should take if you plan for a hybrid event under the conditions of uncertainty, because right now we may seem that in 2022 situation will be definitely better and we will be able to hold live meetings in one form or shape, but we can easily be in a similar situation next year when everything is uncertain or COVID is still there and it's wave number 7, 8, 9, whatsoever. And you have to proceed planning a big meeting. And if you're planning a big meeting, you cannot really be extremely flexible until the very last moment. So what do you need to put in your contract right now, planning for 2022, a hybrid event? And what clauses should be there in case COVID is still there and you have to turn it back into a virtual meeting, or if your hybrid meeting takes place not in the way you originally envisaged, and let's say your live part is much smaller or completely different. So that's the major question, how to plan your hybrid event under circumstances of uncertainty still.
Kathleen, do you want to respond to that right away? Yeah.
Yes, I think that we can give you some elements, but an answer, a black or white answer, does not exist. So it is true. this year is very uncertain. Next year, everybody hopes that it will be more certain, but we don't know. So my advice, if you enter into new contracts now, that you don't take a situation of certainty, but that you envisage a situation of uncertainty. And then, so the solution is when an organization really wants to have its event or its congress, that you work out the two options in one contract and that you discuss on the budgets for the two options, and also that you determine the elements of the budget that are specific for the physical congress and the elements of the budget that are additional or specific for instance, the online congress, to avoid when one day you will have to choose the one option or the other option, and that you have to get into an agreement on the costs already paid, because that will be often the discussion when you have to switch. For instance, you have already started with the organization of your physical meeting and you have already made some costs. Not all the costs can be used for the organization of the online meeting. So determine the costs that are exclusively made for one format and costs that you cannot use to switch to the other format. That's an important one. But there is no magical formula to say, okay, you plan a congress for instance, May 2022, and it should be to start a physical congress, and you start to prepare, but then the date is coming closer, and all of a sudden there is a new wave of the pandemic, which makes that you will not be able to continue with a physical congress. There is no magic formula for the arrangement of those costs. They are lost, and the contract should provide a clause that says who will bear those costs that have been made and that cannot be used for the changed format, the online format. So you should think of that when you conclude new contracts now. But thinking of a magical formula that you can that you provide for a physical congress with a certain budget, that it can be switched to an online congress without additional costs, that will not be possible. But you should think of who will bear those costs, what costs will be recovered from one format in another format.
Thank you very much. That's already very helpful. So we know that there is no magic recipe, but those general lines to take, they are very, very helpful. Thank you.
Was it Philip next or Stephanie, or who wants to go next?
I can go next. I can go next, no problem. We had some very good discussions. I think some of the experiences that we've had in terms of current negotiations have been that venues are currently very flexible, very willing to get things rolling again. So therefore, this is a good time to negotiate. Many, again, are anxious also to get contracts in as well. So it is a good time to look at some of these things. Some of the things that we have looked at are specifically making sure that every eventuality is covered in potential cancellations of part of the Congress. So, i.e., if you have people coming from many different places, it could be that whilst the country of the venue is not locked down, some of the countries of the participants could be. So we've been very keen again to look at how you could offset that in a contract that says if a particular participant's country is locked down, then they would not be able to participate. We've looked at contracts where we have two for this year already, where we actually have a 3-week and a 6-week cancellation policy, no strings attached. So we can take a decision at that point. If we decide to pull it, there are no costs. The other thing we've done is to negotiate and to look at extreme reductions of numbers. So having in the contract the ability to reduce numbers by up to 60 or 70%, and again over perhaps several dates. But again, looking at that as a principle, and that then would enable us to switch to potential hybrid scenario where we've got fewer people actually on site. Other concerns that were mentioned are not all related to the venue, but refunds for participants or refunds of part of the element. So if you start as an on-site event, but later have to convert it, how do you make sure that the participants know what they're getting back, or if they're getting anything back, and what are the likely demands from the participants? You've also got costs involved in that as well. And another element was your contract with your sponsors. That also can be an issue in the event that you have to change the format, or you eventually have to cancel, where you potentially would need to refund that. So again, those were some of the key concerns and key points that came out from our group here.
Yes, thank you, Philip. I guess that also relates to cancellation policies in general for our attendees, virtual, in person. I think there we also need to be a bit more flexible. Last week someone said, Kai, I don't think early bird registrations work these days. I don't know. I don't have the answer, but there's a, makes sense to a certain extent. Is it Bruno?
Yes, thank you. I helped my group to digress a little bit, which is in my habit, but I do concur with what Philip just said, that indeed venues, and this was confirmed, that venues are more flexible these days. That's one thing. I steered our group in the sense that trying to, one step before that, how difficult is it to change your board's mindset and dealing with the, as was said, the optimist, the pessimist, and the realists. What can you really do? I mean, I hear from the people in our group, events were postponed, and then from April 2020 to April 2021, very soon that was not possible either, etc. And it's always this perspective of when is all this going to be possible is, I think, an important one. And I try to trigger the fact that it is really linked to the geography where your event was originally planned to take place, or the mindset of where you are. The consensus is this is really still across Europe, despite the fact that the measures in some countries are opening up. As you can see in Germany yesterday, massive departure for Mallorca. It's incredible. I cannot even go to Holland, which is less than half an hour drive from me. So it's very difficult. Moving into hybrid, how can we indeed change those contracts that we don't lose all our deposits? And recuperating, this was mentioned just now in the chat, following up on our session, is deposits from 2019, which have not been, our colleagues here have not managed yet to maybe move those into, or make it a floating deposit to a future event. So I don't think there's one solution yet. I think that's what we can say. An aspect we did not cover, and I think this is in addition to what your partners from Korea mentioned. I think an important aspect is to, when you review your contracts, and MPI did a session on that, on really review it with your insurance broker. And if you don't have a broker, or you haven't spoken to them recently, call them in and put that together with your contract, with your legal partner, because there's aspects there that change and which might make you spend less money or lose less money for the moment.
Indeed, Bruno, insurance, another big topic. I think that could be another extra session, and I'm glad you internally had that session. And if you are interested to share more of the outcomes with the participants, then you are very welcome to do so. I think we understand we run a bit late. Some people left already, but if you still have 5 minutes, then we would take one more question. And I see Stephanie nodding her head. I guess that means.
Yeah, we did have one question for Kathleen, if it's possible. It was a question from Lien that who said that moreover, in hotel contracts, you usually, even in general times, you have the clause where it says you have to pay the deposits in time, you know, like a 10%, 20%, whatever, all the deposits. If you don't pay them, then the hotel can cancel the contract on their side. So now the question is, how far can we go into taking this risk right now in this uncertainty? Do we have to pay the deposits as mentioned in the contract, or can we wait a little longer without risking the hotel canceling our event?
I think if you envisage this, yeah, that's always the concept, how to approach this. So you will organize an event and you want to book the venue, making available the venue on the moment of your event. This is an obligation of the venue. So when the measures forbid you to organize your event with the attendees you planned, then the venue is not able to make its location available for your organization. And this is, it's difficult to say that it is force majeure when the contract is concluded. And now, knowing that we are in a pandemic, I suppose that's the case, that you don't talk about a contract of 2 years ago. But you can say now, when a venue enters into a contract with you, it is knowing that there is a risk that it will not be able to put at your disposal the location. And then, like I explained in the first part of the session, then he is in breach. And when a party is in breach, the contract is terminated. Or should a judge still qualifies this as an event of force majeure, the contract is also annulled, and everybody has to give back what he has received. So your deposit, your advance payment should normally be paid back because you haven't received anything in return for your advance payment.
Okay, thank you. I don't know, Lien, if that answers your question, or if you...
Yes, absolutely. Thank you so much. I just wanted to add, I think it's a little bit different if you're talking about a hotel and agency. Somebody was talking about working with PCOs, because with a hotel, I'm not saying no service is provided until close to the event, but a lot of what you would be paying for is really for blocking the space for somebody else not being able to, you know, to book the space. But if you're talking about an agency, it's a service, and a lot of the service is actually provided. So, I mean, we're not here to discuss how to protect agencies, obviously, but I do think it's a legitimate concern as well, that if you've engaged, you know, you got staff working, you're paying these people. So how does the force majeure, can you just say, oh, it's force majeure, so everything is reimbursed if you've been working on a congress for 2 years? I don't know if there's a clear answer to that, but I think it's a difficult one. And the client should know about it, because ultimately the client, you know, works with the agency, right? If the agency goes down, the client, you know, it's not to the benefit of anyone, really.
Yes, I remember very well everybody saying last year already, we are all in it together. And regardless sometimes what the legal situation is, I think, or I would hope that everybody plays by that slogan in the next weeks and months to come. We are running late. I apologize. We still have okay number of people there, but I would say we close it here. If you feel we should have a follow-up session on this with more concrete questions that you might have, then we are happy to do that. That's for sure. And if you ever have any suggestions on any other topics or sessions related to legal or not, please let us know, forward those suggestions to us, because this is really how the online session topics and in-person, hopefully soon in-person workshops come about, because we usually have those topics and themes forwarded to us that are of interest to the associations. So with that, I would like to say that we share that information, of course. If you, and I think if MPI agrees to it, we will collect some of the questions still discussed in the breakouts, and we will share that and forward them, and then see how we get some of those answers to you. Please, I think one thing is very clear to me and to the organizations that I work with. We probably need more legal advice more than ever before when we go into new signings, new negotiations. It is probably a clever investment before something bigger happens to us at the very end, because at the end of the day, you know, we are liable also to our members who are asking unpleasant questions when we don't do and decide the right things. But I would like to thank again the Courier team. It's never easy to answer those questions very specifically. We could spend a day on this, and thank you very much, Kathleen, Sarah, Jasper, for your professional expertise. It's very much valued, so thank you for doing that, and hopefully if there is a follow-up session, you'll be interested in joining that and provide that professional expertise as well. Caroline, I think your domestic market is probably one of the first ones opening again. I mean, there are a few things that go right in the UK and England and in your region there. So from that point of view, I think you're probably the first one that starts domestic business again. So that, of course, is great news. I think it would send out a message to the rest of Europe on how that can be done right. And with the advancement of the vaccinations, and also congratulations to that. A lot of countries don't get that right, but it shows that once it is done and done correctly, that you can revive that domestic market again, which for us is, of course, also so important. So hopefully the session brought some answers to you as well.
It's been an amazing session, and thank you for the partnership in it. All of this feedback is so valuable for all of the industry in England, because, you know, we do expect national events to come back as of the 21st of June, hopefully. And but, you know, our international business is so valuable to us. I mean, prior to COVID, conference business was worth 18 billion to the UK. So we really want to see our international visitors come back.
Yes, thank you for that. And I mean, I think generally the industry is not valued enough. I think we saw that throughout. There wasn't enough, isn't still enough lobbying and advocacy for it. For those of you who joined the BF session with David McNair on advocacy and campaigning from the One campaign, as you might remember, they are currently having a fundraising campaign for $100 million trying to raise the money for 1 billion vaccines for the developing world. And the topic of his session was just because we have a vaccine doesn't mean the pandemic is over. And I think that is something we in our industry have to realize and understand, that we are probably not going across the world organizing our events with a couple of thousand people too soon, but most likely we stay in our region, wherever your region might be. So just also from a safety perspective, I think this is probably what it is going to be. And I would wish sometimes that the industry understands that a bit better, at least we can bring our national members, or from a sub-regional point of view, our members to those events. But I think that is something we also need to understand and play safe. So good luck to all of you in arranging, organizing your events. The discussions that you have internally, they are always not easy with some of the boards and secretary generals of you who are not. But I think everybody is in the same boat, and it probably brings in more people into the discussion than ever before. Whereas before we had an event team and they, you know, focus on events. Everybody is brought in now, secretary general, boards, to discuss that, because it is a lot of money that we have or don't have when we do these things right or wrong. So good luck to all of you. Best wishes, and we'll hear each other soon. We are taking a break of 3 weeks with the Association World workshops, because we are finally launching our new website and the community-based initiative in the first week of April. So we are focusing on that, and then hopefully we'll see many of you back. I also want to mention MPI has regular events. You see their MPI website in the chat. I think there's even an event tomorrow and on the 30th, and then the MPI coffee, which is always a great session, on the 8th of April. So have a look at their website and hopefully see some of you there as well. And thank you again to all of you, and best wishes, and stay well.